my 1 minute warning. Good afternoon. I want to welcome you to Washington Legal Foundation's media briefing series. I'm Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 39th year of continuous advocacy and education on free enterprise principles such as the rule of law, limited government, and reasonable regulation. This issue that we're talking about today is one that the Foundation has blazed a trail, I think, in the law and in the regulatory realm more than any other institution that's been involved in this. We're very proud of the track record that we've built up both as an original litigator on this issue and as an amicus filer as well as a regulatory commenter. Done a lot of publications on it as well from our publishing side, and this is probably the fourth program at least in the last several years that we've done in this particular area. I'm going to introduce our moderator first, and I'll hand it over to him. It's Eric Grannon, who's a partner with White & Case here in Washington, D.C. He is also a member of the Foundation's Legal Policy Advisory Board. Eric, I will turn it over to you.
Thanks, Glenn. Before introducing our panelists today, I also want to take a moment to acknowledge the special role that the Washington Legal Foundation has had in essentially creating the area of law that we're going to talk about today. As Glenn alluded to and is further detailed in the WLF's legal backgrounder that was published just last week, it was the WLF's cases in the late 1990s, including Washington Legal Foundation v. Friedman in 1998, that first successfully challenged FDA guidance limiting distribution of scientific publications to the medical community. So it's particularly fitting that the WLF is hosting this program today to talk more about the recent progeny of those cases upholding First Amendment rights for life sciences companies. And we've got a great panel today to help us through this. There are practitioners who have advised companies on these issues both as in-house counsel and outside counsel, as well as having experience working within the FDA. Our first speaker this afternoon is John Osborn. John is a senior advisor at Hogan Lovells here in Washington, where he advises clients on corporate, commercial, public policy, and regulatory matters with a particular focus on life sciences and healthcare clients. For more than 20 years, John worked as a senior executive and general counsel with leading life sciences and healthcare companies, including Cephalon, Onyx Pharmaceuticals, Dendreon, McKesson Specialty Health US, and a Merck joint venture company. John is the author of a frequently cited article in the 2010 Yale Journal of Health Policy, Law, and Ethics called "Can I Tell You the Truth? A Comparative Perspective on Regulating Off-Label Scientific and Medical Information." Our second speaker this afternoon is Ed Berg. Ed is a vice president and associate general counsel with Sanofi US, where he works closely with the medical and commercial teams on product promotion and communication issues. Ed has worked on these issues, among many others, as in-house counsel as well for Merck, Cephalon, and Bristol-Myers Squibb. In addition, Ed represents Sanofi's interest as a member of the Medical Information Working Group, which is engaging with the FDA on how the First Amendment may be incorporated into the agency's regulatory scheme. And our cleanup speaker this afternoon is Coleen Klasmeier. Coleen is a partner in the Washington office of Sidley Austin, where she chairs the Food, Drug, and Medical Device Regulatory Practice, managing matters on behalf of leading biopharmaceutical and medical technology companies. Coleen has been deeply involved as an FDA regulatory counsel in defending numerous off-label marketing investigations, as well as a wide variety of product liability, consumer fraud, Hatch-Waxman, criminal, and appellate matters on behalf of life sciences clients. Prior to joining Sidley in 2005, Coleen worked in the FDA's Office of the Chief Counsel, and I'm proud to say that Coleen is a fellow member of the WLF's Legal Policy Advisory Board. So with that a brief introduction, I'm going to turn it over to John, who's going to walk us through some recent developments in this area. And there'll be a session for Q&A at the end, but if you have a question that comes to mind while the speakers are presenting, please go ahead and send it into interactive@wlf.org. John?
Thanks, Eric. Thanks for the introduction. And certainly thanks to the Washington Legal Foundation for holding the program, and as Eric mentioned, for the ongoing advocacy that Rich and Glenn and others have been engaged in for a number of years. Many of you recall these cases that Eric alluded to, first developing in the late 1990s in the Federal District Court here in Washington that challenged the FDA's regulation of scientific and medical information. And I see these cases clearly, although they're frequently cited as setting the stage for these more recent developments, somewhat extraordinary developments that Eric alluded to that have come about in the last few years. So what's happened of late? I know that many of you who are here and who are perhaps watching on the internet feed are aware of this, but I think just to set the stage for the discussion, I at least want to review some of the recent developments. Several years ago, 2012, the Second Circuit decided a case called Coronia. And by 2-to-1 vote, the majority held that a sales representative named Alfred Coronia, who was working for Jazz Pharmaceuticals, couldn't be prosecuted lawfully under the Food, Drug, and Cosmetic Act for promoting a drug called Xyrem for off-label uses. Now, I know some people believe the government may have made a tactical error in choosing to prosecute a lowly sales representative, but at least partly on the basis of the pleadings and the arguments that were set out and framed in the lower court, the circuit court found that Mr. Coronia was in fact prosecuted for his speech and that this violated the First Amendment. Relying on Coronia, more recently, a small company called Amarin sued the FDA in May of last year in the Southern District of New York. They wanted to enjoin the FDA from precluding, again, off-label promotion, this time of a drug called Vascepa, for the treatment of high triglyceride levels. The government, referencing Coronia in part, tried to suggest that the speech in question was not itself necessarily unlawful, but it was really just evidence of the bad intent in an unlawful scheme to misbrand the product. And without getting into all those technicalities, the prosecutors tried to distinguish Coronia by suggesting that their colleagues in the case may have made a mistake in the way that they characterized the allegations. But the judge in the Southern District, Judge Engelmeyer, pretty clearly was unconvinced. During oral argument, the judge at one point said, quote, "If all you've got is speech and nothing more, aren't you flatly inconsistent with Coronia?" And the exchange really went downhill from there with respect to the prosecutor's perspective. I think that exchange really presages ruling. He granted an injunction against the FDA, which eventually led to the agency determining that they would settle with Amarin. That happened in March, and it allowed the company to go forward with its promotional campaign. There were certain limitations on what they could do and certain provisos that the judge laid out that suggested that he might have to make additional rulings. But in essence, the company won the case. And as an aside, I just say that even though it was merely a federal district court case, the level of detail and the specificity of the ruling, I thought it was an extremely powerful ruling, not only in reiterating Coronia's holding, but the articulation of the reasoning and the way that the judge reviewed in great detail both sides' position as well as the result. Now, more recently, a case called Presira was decided. The company received a warning letter from the FDA, and then after deciding to respond and issuing a corrective action, determined that they would file a lawsuit. Whether or not they were looking and thinking about the implications of Amarin, I'm not sure. This was a case that involved the promotion of a product for the treatment of various kinds of post-surgical pain. The product had initially been approved only for a couple of narrow indications, a couple of narrow cases of narrow surgeries, I should say. And the company, after deciding to sue the agency, argued that the promotion really wasn't off-label, and even if it was allowed in the First Amendment. The interesting thing about this, among others, is that the FDA decided not only to settle the case, but at least as I recall, it's the first time that they ever withdrew their warning letter. And there really isn't any public record of the warning letter that set this all off. And finally, a case called Vascular Solutions. Case was actually the subject of a very recently issued essay that the WLF published. A Texas jury acquitted the defendant of off-label promotion allegations in February of this year. The company was accused of promoting a device called Verilase to treat a particular kind of varicose vein that didn't seem to be initially cleared by the FDA in the device approval process. Nevertheless, the jury acquitted them of the allegations. So what in the world's going on here? For over a decade, the Justice Department has investigated and threatened companies. Industry has paid something along the lines of $13 billion in fines and been threatened repeatedly with civil and criminal violations. And looking at this record, at least over the last year or so, it's pretty clear the Justice Department is amassing a losing record in the courts. And the FDA, for its part, is widely seen to be capitulating and in fear of further uprating. You know, as an example, the number of warning letters coming out of the FDA has taken a southerly turn. And the kinds of warning letters that are going out focus more on safety issues and not so much on off-label uses. So where's this all headed? Well, the FDA has been saying for quite some time that they're taking the First Amendment seriously. And of course, that's good to know. But the long-promised comprehensive guidance that Coleen and Ed, for example, have been working toward in the Medical Information Working Group has yet to be issued. The grapevine scuttlebutt is that there is guidance and that it has wound its way up to the top of the FDA, but that folks at the Department of Health and Human Services were not happy with it. My panelists may have more to say about this, but in any event, it hasn't yet been issued. Now, I admit to being a critic of the FDA's policy in this area, and so perhaps it's ironic, but I must say I do find it very disheartening that the agency has not engaged either directly with industry or indirectly by issuing guidance. Because I continue to believe the FDA can play a very constructive and a critically important role in this area. So as sweeping as these rulings may appear, they don't limit the agency's prerogative to approve new drugs. They don't limit their prerogative to modify the existing labeling. And they certainly don't limit their prerogative to provide guidance as to what the agency really believes companies ought to be able to say and a framework in which they might be able to say it. So with all that said, from this recitation of cases, it's still not the case that courts have really guided companies as to standards that would determine whether or not the scientific and medical information is truthful and not misleading. Certainly there's no constitutional protection to say things that are false. Some have suggested that we ought to use the standards for veracity that are embodied in the 1940 Lanham Act, which relates to consumer advertising, trademarks, and other such things. You know, the definition in that act is not particularly extensive. It does have the advantage of you know, if we were to do that, if Congress were to adopt a standard that made reference to the Lanham Act or directly incorporated it, I suppose it does have the advantage of embracing a good deal of jurisprudence that developed through the 20th century. But it seems to me it isn't that applicable because you're really talking about outward-facing consumer advertising, and it involves things like shampoo and mouthwash. And to me, it really cheapens or coarsens a discussion of medicine, which ought to be very serious, to say that we're just going to follow consumer advertising standards for truthfulness. So I'd suggest that the field of medicine deserves a more serious and a fresh set of standards that really befits medicine. So how do we decide this? Where are we right now in terms of truthfulness? Well, I would say that unless the Supreme Court rules otherwise, I think we can be confident that the FDA no longer has the province to decide on its own, as it has for many years, in saying it's either in the label or it's not. If it's in the label, it's true. If it's outside the label, it's false, and it's subject to prosecution. As Judge Lambert said in one of the WLF cases, rather famously, and I think wonderfully, the FDA, quote, exaggerates its overall place in the universe when it asserts that scientific claims are false unless they're established by the agency. And he reiterated this, in essence, in the Vascular Solutions case. So I think it's clear that is no longer likely to be the state of the law. I think it's also apparent that companies don't need to produce what is heretofore been considered substantial evidence of efficacy, which is the usual standard for an approval of a product. You conduct placebo-controlled pivotal studies in a clinical setting, and you reach endpoints, and you receive an indication. On the other end of the spectrum, though, I'd also hasten to add that I don't think companies are free to say anything they want. I don't think we're really going to return to the old Wild West where people are promoting what's good for what ails you off the back of a covered wagon. It can't be the case, at least I don't think it's reasonable or even ethical to say that companies can resort to repeating what I might call treatment anecdotes that just represent some such purpose by some such named physician that somebody's observed. That can't be right. There really ought to be a middle ground that I think would reconcile the First Amendment principles that we all care about with a reasonable regulatory regime. So I'm sketching out a few factors here that we can all talk about as to things that people might look at in considering whether the speech about an unapproved indication is truthful and not misleading. First, the presentation should be based on real science. And perhaps, as I've said, not on the scale of a pivotal study, but real scientific data nevertheless. Even better if the data has been published in a peer-reviewed journal, which, as I think most of you know, has been the subject of an FDA guidance and is allowed under certain circumstances at this time. Third, the presentation ought to be fair and balanced. And that is an existing standard, as we all know. But I would say that especially in the sense that the risks and the potential safety concerns that are associated with a potential new indication really ought to be outlined. Fourth, the presentation should disclose, where relevant, the context in which the information was developed. If it's a small study, you need to tell people it was a small study, the nature of it, the way in which the information was developed. Fifth, the new indication has been generally accepted by the medical community. Perhaps there's a specialty group, a medical specialty group, that has determined that the use of the medicine for the new indication actually has come to constitute the appropriate standard of medical practice. Next, the new indication for the drug or the biologic might be listed in one or more medical compendia, U.S. Pharmacopoeia Drug Information Reference Book, for example. And finally, the new indication, if not widely, is at least generally reimbursed by private payers who've reviewed the use. So, I've given my colleagues and those in the audience a lot to shoot at here. I'll be careful to, again, say that none of that has really been articulated or embraced. I think some of those standards are consistent with the way that good companies think about this area, and I'm sure Ed and Coleen will have more to say about it as they present.
Thank you, John, for setting the stage and speaking to the landscape currently. I would be remiss if I didn't start by giving the disclaimer that anyone who works for a pharmaceutical company would give, which is that, of course, the opinions are my own and don't represent those of my company. I have worked at 4 different pharmaceutical companies, so I have a sense for where the industry would like to go with this information, and I can and will talk to that. I don't speak on behalf of everyone, but I think I can give a sense to it. I was asked to address really 2 questions at the outset. So taking you back to the landscape, how should companies regard the off-label landscape at this point? And how should they handle off-label information? And I have to say that unfortunately, my answers are warily and very carefully, because as John has pointed out, the landscape is not at all clear at this point. And while John has set forth some very interesting standards, those standards have not been adopted in any way that we can point to, and therefore, for companies, there is a lot at stake. In fact, misbranding remains a statutory violation of the Food, Drug, and Cosmetic Act, and it's one for which a company could face exclusion. And if you're a public company, exclusion is the type of thing you don't want to talk about with your CEO. I point out that the case law, Amarin, Coronia, Casira, Vascular Solutions, is all trending the right way from a First Amendment standpoint. But there are aspects of the case law that still give pause. For instance, the Coronia Court, citing the concept of constitutional avoidance, didn't strike down misbranding, left it intact, but also didn't elucidate what misbranding would be. It merely said that it couldn't be predicated on truthful, non-misleading speech alone. Similarly, in Vascular Solutions, Judge Lamberth, while adopting the standard essentially that ran through Coronia and Amarin about speech alone not being a misbranding, did say that evidence of misbranding could be introduced based on internal company documents. That leaves some very interesting questions on the board. If I provide, for instance, scientific article, and I have an intent to create a market for that drug, is that evidence of misbranding if someone can prove there's some aspect that is false or misleading? But if I don't say I have that intent, if there is no document, then the intent hasn't been proven. It presents some interesting issues for industry that haven't yet been decided. I also point out that the concept that in Coronia was discussed was the idea that there would be speech plus that could still be misbranding. So speech plus something. But of course, it's unclear what that plus is. So if you're in a pharmaceutical company, you start looking at all the other activities that your company is undertaking, and you're not sure which of those activities might be deemed by a prosecutor to be sufficient to bring a misbranding case on the speech plus theory. Would a reimbursement support program that is not narrowly tailored to only the patients for whom the drug is indicated be enough of a plus factor? Would a set of pricing terms that also were not narrowly tailored be sufficient as a plus factor? Or would a prosecutor defer only bring a case when the action was designed to create an off-label market? And then what about all the documents that essentially end in speech? In other words, we are going to engage in creating sales by speech. Do those get some kind of special treatment as a plus factor? Or do prosecutors and the courts believe that, in fact, because they end in speech, they are about speech, and this remains a First Amendment case? So those are some of the questions that companies have to ponder. And as John has already talked about, false and misleading is not well defined. We know that it can't be the basis alone for misbranding provision, but we don't know what false and misleading actually constitutes. I think it's been widely speculated that false and misleading is going to be the way that prosecutors continue to present their cases. And I point out that Vascular Solutions suggests that those cases will often be brought to a jury, and I don't think that pharmaceutical companies feel very comfortable with those cases going before a jury and taking their chances. So again, a reason to be very wary of the landscape at this point. I also want to point out that pharmaceutical companies, and this goes more towards what should they do now and how should they deal with it, pharmaceutical companies aren't really developed with this new landscape, whatever it is, in mind. They've been constructed with the old landscape in mind, with the old regulatory regime. So companies aren't designed to navigate through First Amendment issues. Most companies have review committees that review promotional advertising and other communications to healthcare professionals and payers. In almost every one of those circumstances, the people who staff those committees are from regulatory, medical, or legal professions. They are usually steeped in understanding of what the old regime required. In other words, Section 202.1 of the FDA regulations, the OPDP view of the world, and therefore what is false and misleading under the old way of thinking about drug advertising, some of which may well still survive, by the way, in the new regime, but all of which cannot, since, of course, off-label information cannot by itself be the basis for misbranding. In any case, the people who staff that have spent years understanding what OPDP wants, the way it thinks, the regulations, the enforcement environment, and they're highly likely to see the world through that lens until there is another lens to put to their eyes and view what misbranding might be. And so companies are a bit adrift trying to figure out how to deal with these issues. And finally, on that front, the front of how companies have to deal with it and what the internal dynamic is, actually two things to say about that. One is many companies either have or have had corporate integrity agreements. Those corporate integrity agreements were drafted with the old landscape in mind, with the old regulatory regime. Companies are used to it, and not only that, the stakes are that much higher with corporate integrity agreements. People have to certify to meeting FDA requirements. That certification is a bit terrifying to some. That certification means that I with reasonable certainty have to believe I'm following the FDA's requirements, and when FDA has not put new requirements forth, I will go back to the old requirements. So again, reiteration of the idea that there is a new world possibly out there, and there's some recognition, but there is not a lot of certainty. The other thing to point out is the dichotomy between the way that the courts view First Amendment cases, where the content of the speech is what is really at issue, and the way the compliance and regulatory and practice of speech within companies has evolved. Companies and the compliance officers and the regulatory lawyers and the regulatory people don't see speech as merely content. They see it as content, they see it as context. They're interested in what are the medical people doing, what are the promotional salespeople doing, what is the context of having them together, what is the context of having them separate. They're worried about how the company is organized and where speech gets, where the determination of what can be said gets decided. They are worried about context. And the FDA, essentially, while it in many circumstances, if asked, will say that they believe that it doesn't matter who is speaking, it matters what they're saying. They actually also hew to that in various circumstances. Their guidance documents, for instance, medical information requests coming to the medical department. The Ameren letter, where when the FDA proposed a solution to the Ameren case, they pointed out that medical people should be conveying the information that Ameren wanted to convey or that they believed Amarin should be able to convey. The medical booth at a conference, which is very different than the promotional booth. And of course, the unsolicited request guidance, where the idea is that you are safe harbored if you're presenting on-label information, but you're at sea if you're presenting off-label information and a question comes from it. So there is much that is different than the First Amendment world that is still out there as guidance. So it's a formidable landscape. I have only a few things to say about how companies should handle off-label information other than extremely carefully. I think there are some ideas that run throughout both the agency and even the company's viewpoint about this information that can be a common ground for some work. First of all, the people who are listening to the information and understanding the information should understand what the FDA has approved and what it has not approved. And one way of doing that is obviously the separation of promotional labeled information and off-label information. The second is that it makes a lot of sense to talk scientifically about information outside of the label. While there are advertising phrases used in promoting drugs where the studies that support them don't meet substantial evidence, it becomes harder to figure out what advertising phrases should be used to talk about off-label information, especially in circumstances where essentially two adequate, well-controlled trials are not the basis. And then finally, balance. I think that there are areas of scientific controversy. When I think of balance, I don't think of fair balance in this area. Instead, I think of the balance of presenting both sides of the scientific controversy. So if there is a theory and there is a study that might tend to prove one theory, it's also worth mentioning what the other theories might be. And then I will close by saying that I would suggest that the First Amendment really should allow physicians and payers to gain valuable information and make up their own minds about the value of that information and how it affects either their prescribing or the formulary status of a product. And that really is the idea of the First Amendment. And I think that is something that both industry and the agency can work towards. There's a lot the industry would like to present. A lot of it is not about new uses in new populations. And I think that a lot of it is valuable information for payers and physicians. So with that, I'll turn it over to Coleen.
Thank you, Edward. Good afternoon, everybody. It's always a delight for me to be involved in any way with WLF programming, and I'm really pleased to be sharing the dais today with so many terrific lawyers and speakers. I also want to thank WLF for its leadership on this issue. It's not an overstatement to say that but for WLF, we would not be in the relatively favorable position that we're in with respect to First Amendment case law developments and FDA regulation. I also want to thank Ed and John for their leadership on this issue, and to Eric for moderating and for his kind introductions. I want to say a few words about the Medical Information Working Group, just because some of you listening in may not be entirely familiar with what that industry coalition has been up to. And I'll say a little bit about what our FDA engagement has been over the past 10 years. And then I'll talk a little bit about some of the specific regulatory changes that I and MIWG variously think it would be prudent for FDA to implement in view of the changing case law landscape. The Medical Information Working Group is an ad hoc coalition of the major manufacturers of drugs and medical devices, formed 10 years ago in order to improve the regulatory and enforcement climate for the dissemination of information about unapproved products and new uses of inline products. Our membership is not completely overlapping with that of pharma. We have some members that are not pharma members, and the positions that MIWG has taken have not always been identical to positions that we understand pharma to have taken. We also enjoy coordination with AdvaMed and Bio in addition to pharma. So I think what we tried to do is use MIWG engagement as a vehicle for showing FDA where there seems to be consensus among some of the major industry participants in the policy debate. Significantly, in my view, one of the things that the MIWG has quite self-consciously not done is argue to FDA or to anybody that the entire existing system for the pre-market review of products should be dismantled as a result of First Amendment principles. Neither has the MIWG asserted that FDA should get out of the business entirely of reviewing even post-market speech for new uses of approved or cleared products. So in that sense, the group is quite a moderate voice in the debate. We're not taking the Hoover approach of saying FDA should just shut the door and turn out the light and go home, which makes sense if you think about the nature of the business of the innovator industry. These are companies that succeed or fail based on the strength of the data they can generate in extraordinarily expensive clinical trials. So it just doesn't make any sense for them to advocate a shift to a regulatory environment in which they're competing against snake oil salesmen who are making claims without the same demanding level of evidentiary support required for research-based companies under the current regime. The changes that the MIWG has asked FDA to make have been spelled out in a few different submissions dating back to at least July of 2011, which is when the first citizen petition went in. It was day after July 4th, 2011. And in that submission, the MIWG laid out a few what we thought were pretty modest requests of FDA to improve the regulatory landscape. In September 2013, we added a second citizen petition to the mix. And the timing of that matters because the second CP reflected the intervening developments in the Second Circuit decision in Coronia, which John talked about. So it made sense in the second petition for the MIWG to be saying, in addition to all the stuff that we asked for in 2011, which in retrospect looks a little like rearranging deck chairs on the Titanic, we think you ought to take a step back and look at the entire regulatory scheme, FDA, and make it consistent with the statute and make it more constitutional. That was also a very deliberate choice in terms of our language because we did not say render the scheme entirely constitutional. Our concern with saying that is that we would have in essence been asking FDA to eviscerate the very regulatory system that the research-based industry depends upon for third-party adjudication of efficacy claims. So here are the basic asks that are still on the table because although FDA has been working hard in responding to the petitions and has been making yummy noises in response to some of our engagement, the agency's response has by and large been underdeveloped. So it's worth kind of reiterating what we've asked for. 3 clarity-oriented changes. So back when, you may remember the expletives case, the wonderful FCC expletives case, which is, I think, the only time my partner, Carter Phillips, has actually stood up. I think it's the only time he's ever stood up in front of the Supreme Court and said the F word. That case stands for the proposition that as a due process matter where First Amendment rights are involved, the government has to speak with exquisite clarity, or at least more clarity than it's speaking with now and was speaking with in that case. So the clarity-oriented changes are what I consider to be FOX 2 due process kinds of changes. The first one is to clarify the definition of labeling. So for those of you who are familiar with the Food, Drug, and Cosmetic Act, one of the key definitional provisions says that labeling is written, printed, or graphic matter, blah, 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 accompanying a drug or device. And there's case law, including 2 Supreme Court cases, purporting to explain what accompanying means in the definition. There's been some drift, not to say seismic shift, away from that core definition as the Supreme Court explained it. And I think the high watermark of that drift, to continue with the maritime analogy, is in this one regulatory provision that seems to say everything in this long laundry list of different kinds of things, like brochures and mailing pieces, shall be deemed to be labeling. And that's a problem because what that does effectively is expand the scope of FDA's jurisdiction to include all of those things as a categorical matter rather than applying the terms of the Supreme Court cases explaining what the statutory definition means. So as a result, manufacturers don't really know whether any particular piece of writing that might or might not even mention the drug is within the scope of the labeling definition and therefore subject to all the content regulatory provisions that FDA applies to promotion. We have asked for FDA to clarify that labeling means what the case law definition says it means. And there actually happens to be a regulation on the books in Title 21 of the Code of Federal Regulations that is a generally applicable definition of labeling that cuts across all FDA-regulated product categories. And we've said that's a much better reflection of the case law, and that's the one FDA should apply in the drug and medical device context. The second thing we've asked for is clarification of the scientific exchange safe harbor. There's a reg that's been on the books since the 80s that says, in essence, FDA recognizes that it cannot seek to regulate the content of information provided by a manufacturer in the course of scientific exchange. And there's some really helpful preamble language that we are asking to be codified because it explains essentially that a manufacturer can talk about an investigational product or new use of an inline product as long as it satisfies 3 pretty reasonable criteria, one of which is that the manufacturer will disclose that the use that it's talking about is a new use, or will disclose that the product that it's talking about is an investigational product. So various sort of pro-speech principles. FDA has not responded to our ask on labeling, has responded to our ask on scientific exchange by publishing a request for comment, and that happened after our first CP, so December 2011, FDA published that thing. Since then, I'm not aware that anything has happened. The third thing that we've requested under the rubric of clarity-oriented changes, it has to do with intended use. And we could talk about intended use for a long time. Others have alluded to it. It's enough to say, I think, that we asked FDA to clarify that the knowledge prong of the intended use regulation is not valid as a matter of statutory interpretation because of the case law. Happily, I can report to you that FDA actually published a proposed rule to take the knowledge prong out of the intended use regulation, and we're waiting for the final rule. It's great because assistant U.S. attorneys like to say that intended use can be demonstrated with evidence that a manufacturer had knowledge in the criminal law scienter sense, or even in some cases according to traditional tort law notions of knowledge, like foreseeability. And FDA has even flirted with those alternative interpretations of intended use from time to time in the past. For reasons that I confess still escape me, the agency nevertheless published this proposed rule proposing to get rid of the knowledge prong, so that's really helpful. That's clarity-oriented changes. Speech-enabling changes is another kettle of fish, and there we've got more work to do with FDA as well. The MIWG on-record asks are pretty simple. As I mentioned, we've just said, do better, be more consistent with the statute, be more consistent with underlying constitutional principles. What I'm about to say is just me talking. I think FDA needs to adjust its substantiation standards to allow more speech not based on registration quality data sources. In the medical device space, we have a good precedent because the relevant regulation doesn't say substantial evidence, which sets a really high burden before you can speak. It says credible scientific evidence or valid scientific evidence, which sets a lower, more flexible standard. So something along those lines could be could be great. I take John's point that when it comes to prescription drugs and medical devices and healthcare, we want to be serious. But I think we can be serious and be flexible. In fact, I think you can be more serious if you're flexible. Second thing I think we need in terms of speech enabling changes is we got to limit the scope of the speech for which these regulatory substantiation standards are going to kick in. Because you got to have, as part of just scientific development in the world, you got to have free-flowing conversation about ideas. And if people think that in order to speak, they got to satisfy a regulatory standard, whether it's flexible or not, that's going to create a chill that's anathema to First Amendment principles. So I think FDA needs to say that its statutory authority goes this far and no farther, and that outside the scope of this category of claims, for example, you don't need to worry about satisfying whatever the ideally more flexible substantiation standard is going to be. The third thing I think we got to persuade FDA to do is to revisit the existing regulations that define what's false or misleading. We do have something from FDA. We actually probably have a lot from FDA in terms of the agency's views on what's false or misleading. It would take a lot of work to pull all that stuff together and try to develop a unified field theory and boil it down to 10 things. I think FDA did a pretty good job with a lot of industry input in the 70s in coming up with a list of 17 things. So if you look in the regs now, there's a list of 10 and a list of 7. And the list of 10 is, if you do any of these 10 things, you are false or misleading. If you do any of these 7, you might be. That's not bad, because it's a very tactically oriented list of 17. And so it can be applied, to Ed's point, by regulatory affairs and other personnel sitting in these copy review sessions. But it probably would benefit from some updating, and I can think of at least 2 provisions that really need to be just changed, because they say, in the absence of substantial evidence, you can't make this or that type of claim. And again, substantial evidence is just a very, very high standard and doesn't really reflect the more heterogeneous mix of information that supports clinical and payment decisions in a post-Affordable Care Act environment. So those are the 3 speech-enabling changes on the substance. I also have to say, I think FDA really does need to do a better job with the advisory comment process. Those of you who practice in the healthcare area know that there's an advisory opinion process available to determine whether a proposed activity is in violation of the anti-kickback standard, and you get good binding legal advice in advance through some engagement with HHS OIG. We don't have that to nearly the same degree with FDA, and that's because we've got regulations on the books, 2 sets of rules that seem to set up that kind of a process, and the regs just are not really followed very well. And going back to MIWG for a second, that industry group requested that FDA set up a better advisory opinion process similar to the Kickback Statute 1. Back in 2010, we asked for that, and in 2011, I love this, I say this with affection in my heart, FDA convened a transparency task force that said to us, we reject your suggestion because, and this is me interpreting the response, we don't want to tie our hands. Industry might get out ahead of us, and so the more we provide clarity, the harder it's going to be for us to bring enforcement action. Transparency task force. So I personally have not given up on that one, and I really believe that this process dimension of the policy development is every bit as important as the substantive changes that FDA needs to make. Companies are, by their very nature, the large ones in particular, risk averse, and if there is a robust, meaningful, business-friendly process that would enable a company to go into FDA and say, we want to say X, and get a response, a good, reasoned response, clear response back from FDA according to a reasonable time frame, I'm guessing most companies would take advantage of it. In the current system, it is not unheard of. It's far from unheard of for it to take more than a year to get comments back that you can do something with, and that's because often the first round of comments you get back will be ambiguous and you need to go back again, or it's because FDA, facing these First Amendment lawsuits, has larded up the internal clearance process for these advisory comments to such an extent that it just takes forever for the letter to actually get signed off on. I want to conclude with this thought. I can't think of any other area where we would be saying at a WLF event that it's not enough for there to be a false or misleading standard. I mean, I think in so many other areas of the law, companies and individuals are happy with a legal standard that says you just can't do anything that's deceptive. It's pretty common. State consumer protection and other laws say you can't do it, Lanham Act, other provisions of the FDCA. It's only in this area of marketing of prescription drugs and medical devices that we seem to say we need the government to tell us in advance what we can and can't say. And that, I think, is a natural consequence of how murky the enforcement and regulatory climate has become through the combined actions of DOJ, the relator bar, and FDA. But it is not a foregone conclusion. There is nothing inherent in the statutory scheme that requires us to need FDA to tell us in a list of 10 or 17 what we can and can't do. I believe and would submit that we need to be brave and self-determine that our speech is truthful and non-misleading. And one of the lessons we should take from Ameren, and indeed from all the First Amendment cases going at least as far back as Virginia Board, is that speech, engaging in speech, is not just a right, but requires a little bravery. And so if we're going to take these lessons seriously, we need to stop waiting for FDA to tell us whether we can speak, and we need to start taking some risks and engaging in some robust self-assessment of the veracity of our speech, and we need to get it out there. And that will help contribute to the development of a climate that we can all safely do business in a way that harmonizes with the First Amendment.
Thanks. Glenn, perhaps you can let us know if we've got any questions coming in from the audience.
Not so far.
Okay. Well, then I'll do my best to stand in for the audience. I've got a couple of questions based on the presentations, and maybe I'll start with John, and hopefully Ed and Coleen, feel free to weigh in as you'd like. John, in listening to your presentation, just one kind of natural thought occurred to me, and I'm wondering how much of the recent industry victories in courts have been a product of perhaps the government overreaching with criminal prosecutions as opposed to proceeding civilly?
Well, thanks for that, Eric. I think that's a difficult question to answer directly. I think I'm going to be a little political and answer the question I'd like to answer that is related to that. And it's very, very consistent with and reflective of Colleen's comments toward the end. I think that the industry's desire for clarity and certainty and concerns around risk does indeed stem very much from the criminal applicability, the risk of debarment, as Ed suggested, the sort of relatively frequent mention or allusion to the Park Doctrine, in which corporate executives could have even criminal liability because they're in a responsible position, even if they really were not directly culpable for the actions of the company. And when you put that all together and you think about, as a corollary, the reputation damage that has come from the headlines and even the real money. I mean, it sounds like Everett Dirksen to say merely $13 billion, a billion here, a billion there. But if you think about those billions of dollars in fines that some individual companies have had to pay, even that is not insubstantial when you think about what they might have done with that money. So I would sort of flip it around and just make reference to some of the work that I did when I was trying to develop this critical essay that you mentioned in the introduction, which was more of a policy essay than a First Amendment treatise. But along the way, I happened to think about the system in the UK. And in the United Kingdom, even though admittedly with the National Health Service, the reimbursement environment is very different, and I acknowledge that, it was striking to me to see that after some controversy, the Brits had come to a system in which the government had oversight but the day-to-day responsibility was largely a quasi-private system of self-regulation. And I think it's worth having us all ask, and of course now I'm on the enforcement side of this and not so much thinking directly about what Coleen and Ed have been speaking of in terms of day-to-day practice, but on the enforcement side, while it's understandable, you know, we do want compliance with the law, and we understand that there are criminal violations for the FDCA. But I think the way in which the misbranding thesis was developed and the application of the False Claims Act, even if the speech may not itself even be false, has led to this environment. Very, very cautious, very, very reluctant to engage. And if you look at the UK, it really is, I think, quite different. There is a level of cooperation that runs through the UK Trade Association. There is even a willingness of companies to, you know, I guess for lack of a better word, to tattle on each other, because there are civil penalties. And the level of, you know, it's not really formal rulemaking, but the explication of rules, you know, goes well beyond the 17 things that you can't do. It's quite detailed. And I think that clearly does go to the civil nature of their system, and the fact that somewhere along the way, whether consciously or not, the Justice Department got hold of this enforcement mechanism. And you know, as I said in my remarks, I would really welcome more thoughtful engagement between the industry, whether it's through the MIWG or otherwise, and the Food and Drug Administration.
Well, thanks, John. Coleen or Ed, any additional thoughts in that area?
I mean, this is, to me, the heart of, maybe one of the hearts of the conversation. You know, John, you mentioned park and exclusion and reputational damage and real money, and I think there are counter arguments on all of those points. Just taking one by way of illustration. I mean, every 10 years or so, somebody from FDA or DOJ goes running around screaming park, and we all go, what? But park is really not park. I mean, park is not vicarious liability. If you really drill down on park, it is an oddball form of liability, but it's not true vicarious liability. And park's bark is worse than park's bite. So I think you obviously got to be worried about it. And if you want to get a business leader's CEO, then go shouting park. Sorry, if you want to get a business leader's attention, go shouting park. And we lawyers love park, but I think park is a little overstated. And there are similar responses to all of those points, which I still think are good, because in the aggregate, if not in isolation, they really do mean you got to be so careful. But maybe less appreciated is we do this all the time anyway. We self-determine the veracity of our speech all the time anyway. It's only in the off-label promotion area that we freak out because of all of the consequences that you described. But we have copy review people, we have regulatory affairs people and medical people and lawyers who sit in rooms and say, that claim is not off-label, therefore it's not prohibited, and the standard that applies to it is a straight false or misleading standard under 502A. Is it truthful and non-misleading? I think it is, and then the speech gets out there. So we do this all the time. We could just now do it in this additional category of speech, which is off-label speech. I also want to add that this notion of a third-party entity is something that the Duke Margolis Center white paper on off-label communications considered, and I was involved in that process. And there was an event in February that you can find on YouTube, in which, to me, remarkably, both the industry speaker from Genentech, Michael Listgarten, and Josh Sharfstein agreed on one of actually a couple things they agreed on, which was heartening, was that this third-party idea was not a good one. And I'm not sure I agree with that, but I thought it was really interesting and intriguing to hear people from what should be both sides of the debate agreeing on that one point. The other thing that they agreed on, interestingly, was that there needs to be a continued robust and vital role for FDA as a juror for scientific speech about off-label uses. So there was a lot more common ground between those two guys than I might have expected.
I guess I see it as an evolution from a set of very sound theories about the falsity of the information that was being provided, to an evolution to looking at the agency as the arbiter of truth in a way that eventually the courts decided was not the case. And it reminds me of relatively early in my career when a company had decided to do a study, and the company had, on a good faith basis, decided that it was going to attempt to do a superiority study of its drug against another compound on the theory that this compound was, in their view, likely to show superiority. Well, it didn't show superiority, but if you looked at the Kaplan-Meier curves, it was quite clear that the drug was essentially equivalent to its comparator. And so if you go to ask doctors what that study was about, many of them would say, well, you have shown something interesting about the comparability of that study. And yet, of course, if you take the purest view of what was shown, the answer was nothing, because you decided to try and show superiority. And to me, that was a striking example of the idea that there is valuable information in studies that don't necessarily meet the FDA standards. And that is, to some extent, what the courts are saying, which is that this scientific information, which is being provided, has value. It is not the null hypothesis. It either meets substantial evidence or it doesn't. And that's what hopefully First Amendment allows, because it certainly doesn't allow falsity.
Okay, well, thank you for that, Ed. Your comments and then something John was saying earlier about the UK system reminded me somewhat of John's opening proposal regarding standards that could be adopted. I guess I'm wondering, that given the kind of widespread acceptance that I heard you to be connoting in terms of having various stakeholders prepared to say that the drug was safe and efficacious for some new indication, I'm wondering what's the benefit of that kind of standard versus actually just going and getting FDA approval for the new indication? And I'm just wondering if maybe you and Ed and Coleen
Well,
have
Ed's,
thoughts on
you know,
that.
Ed is still working with a company directly, so he's, I think, closer than I am at this point to the, you know, kind of day-to-day decisions that executives make. But what is, and I should say, you know, Coleen alluded to the, you know, the 17 things that you can't do, and I guess I was trying to say, well, here's 8 things that maybe could indicate that you could do it. So I mean, the glass is half empty or half full, perhaps. But I think that the things that executives are wrestling with are in the context of a research and development budget. And I know that there are a lot of critics, and they're not all supreme cynics, who would just say, look, you guys are just putting too much money into the wrong things. But I think that you know, budgets are not unlimited, and the costs, both you know, human and financial costs of running additional studies, of coming up with the traditional 2 studies to show a substantial indication of efficacy, is not something that companies would freely embrace so often, unless, I would hasten to add, unless it really is a wholly new kind of use. You know, if you're talking about one of the cases that was sort of the subject of this dispute around pain, you know, where a drug works for pain, and a lot of these cases, I mean, the pain field is a difficult one because drugs that alleviate pain tend to alleviate pain regardless of cause, but many of the labels for drugs that are approved to treat pain link it to the causative factor from which the pain emanates. If we found that a drug indicated for pain is also going to be useful for, you know, sort of an esoteric kind of neurological condition, you really ought to probably go off and do those studies. But I think people, who are wrestling with this issue are oftentimes in a position of looking at things and saying, all right, I'm pretty sure this thing works. I've got a limited budget. I'm trying to drive other things forward. And finally, just sort of a sense, and I must admit, I'm not sure what the data would show on this, but I think many people believe that the FDA just doesn't put a high priority on reviewing and approving supplemental NDAs that would add the new indication to the existing labeling.
Ed and Coleen, do you have anything?
That last point is incredibly well taken. We actually did an analysis of that issue, and it's published in a paper I've got somewhere at SSRN. But we looked at it just in oncology, and it was really remarkable how long. I think there was one at the extreme right end of the curve. It was like 8 years that an SNDA had been languishing in oncology, and it is absolutely because FDA knows and expects that oncologists are going to be using drugs off-label as part of the practice of medicine based on literature and anecdote and clinical practice guidelines and a whole range of other information sources. So yeah, that's absolutely the case.
Yeah, I take it also from an economic policy standpoint. Is it really the best use of resources in the R&D space to require that each and every use of a drug be based on substantial evidence? There are times where the FDA itself has made it very clear that it will use studies as indicators of a broader indication. You study a few different populations and you get a broader indication. So there's a lot of debate in those areas, and there's a lot of room for discussion. But the point is that if you have a drug that seems to have multiple uses, is it better to have someone try to establish efficacy by 2 adequate, well-controlled trials in each one of those uses, let's say 15, 20 uses, or is a company better using its resources from a public policy standpoint, discovering drugs for new uses and new drugs, and spending a little less on use number 12, use number 13. It's an important point for the industry and the regulators to consider.
Glenn, you've got a question?
I want to see if anybody in the audience first had a question before I read the one from the online. So, does anyone have a question from the audience?
I just want to follow up on one of John's comments about the problem of exclusion. I gather that there have been lots of U.S. attorneys who investigate off-label use, and there's lots of negotiations that go on, but I'm just not aware of any case where a company has done anything more than negotiate over how much it has to pay. I guess Allergan maybe filed a lawsuit, but relatively quickly settled. And I'm wondering if there really is any, once a U.S. attorney has started investigating, is there any possibility of actually convincing them on the First Amendment, or is it basically too much at stake for the company so that they're always eventually going to cave in?
Well, there's a lot of negotiation around the amount of money. There's a lot of presentation, if you will, around what lawyers call bad facts, which shockingly often take the form of emails. And there's a lot of negotiation around the scope and the specificity of a corporate integrity agreement, a so-called CIA, as Ed alluded to, and that gets negotiated with the Office of the Inspector General of HHS. The kinds of cases that we're talking about now, either because the company's acted preemptively, or an individual sales representative or a doctor is facing criminal conviction, or there is, in the Allergan case, a pretty clear sense that they are going to get themselves into an uncomfortable area, and therefore they need to be proactive. Those are the kinds of cases that are developing the law. And so, when you look back at these other kind of very large dollar settlements, although the government certainly explicitly or implicitly threatens exclusion, they're usually cases in which the commercial organization has been aggressive, or at least individual actors engaged in statements or things that were very difficult to defend. And the fear of the things that I was tossing out, is there. And also, of course, as with any litigation, I mean, companies are not really in the business of litigating. They're in the business of doing what they do, and they like to limit the risk and the overhang in the stock market that would come from substantial uncertainty. And that could be an antitrust case, or it could be a significant criminal case like this. So that's kind of the dynamic that I think you face. I mean, there had, just one other comment. I mean, there have been statements, and I think even an occasional essay that has said, in effect to the government, hey, stop just crying wolf. Why don't you send an executive to jail? Why don't you, debar a large pharmaceutical company? You keep allowing them to establish subsidiaries and plead and have a CIA. Why don't you really follow through if you really mean that? So, how that all plays out, whether it continues to evolve in the face of these First Amendment-related rulings is something that I think we're all interested in seeing.
And I mean, let's not forget Scott Harkonnen. I mean, that's a case the government treated as a garden variety fraud case and won. Cert was denied, and Scott Harkonnen, former CEO of Intermune, completed his sentence and had his medical license taken away from him and lost everything. So, it's not for nothing that the government talks about going after individuals. I think, Rich, if what you were asking is, shouldn't the First Amendment taken to its logical conclusion mean that the government kind of gracefully bows out of some of these cases without extricating any kind of settlement? I think the answer is yes, but I think human nature being what it is, no AUSA wants to think that she spent 2 years of her life having teams of people review documents only to walk away without anything to show for it. So, I certainly have been in meetings where it was very much about, what's the minimum amount of money you can give to DOJ in recognition of the sweat equity that they've got in the case. It's an odd, in my view, it's an odd way of thinking about resolution where such significant public health and constitutional principles are at stake.
So Glenn, you've got the question from the web audience?
Yes, I will paraphrase. Question is that talked about how FDA likes to look at context when they do their enforcement actions. They don't seem to look at context, though, in the context of the rules that were written applied more to the garden variety doctor meeting with a sales rep in their office sort of approach, especially with regards to things like unsolicited requests and questions. You've got really sophisticated payers and Caremark and others that companies are now interacting with, not the sort of doctor and sales rep is sort of the thing of the past. Why doesn't FDA sort of take that into consideration when they're looking at the current rules and how much they should enforce them and whether there are First Amendment problems with them?
I think FDA should, but I think when you hear OPDP, I mean, this whole content, context, intent thing comes from the program people who sit in what used to be DDMAC and what's now OPDP. And what they mean by that is it's a one-way ratchet. If you tick any of those boxes, it's promotion. And the context one means if there's a sales rep anywhere near it, it's game over. So they don't think of them in terms of the sophistication of the audience. And I think Sorrell taught us in 2011 that maybe there's not a whole lot of utility in thinking about it in terms of audience sophistication. And the Supreme Court has said, you can't reduce the level of discourse to what's appropriate for a sandbox. Justice Stevens said that, and that's pretty good observation for my money. So, if the question is coming from a desire to sort of decipher what OPDP and DDMAC people mean when they talk about context, I think that's what they mean. They mean if the commercial organization touches the activity in any way, it's presumed to be promotional.
I'll just add one quick thing to say that I've been struck by Ken Frazier's willingness to speak out as CEO of Merck and now head of pharma in alluding to the implications of the ACA and the kinds of collaborative efforts between payers and manufacturers and the quest to try to get more effectiveness and efficiency from prescription medicines. And he's, sounded rather plaintive from time to time, and raised this issue, the ability to speak freely with payers, as a hindrance. Again, I think, some folks might hear that and think, there's big pharma again, but I think in a large company with the risk averse version that Ed alluded to, even having a conversation between very large, sophisticated companies about things that are not in the label is still gonna sound some alarms. I mean, and again, Ed is closer to that, but I think that's an interesting perspective that relates to that question, Glenn.
Glenn, any others from the web audience? Okay, well then I'm going to exercise the moderator's prerogative to ask one last question. Coleen, your comments were interesting, and it seems like the working group is having, some measure of success, certainly with getting the FDA to follow the case law regarding the knowledge prong and regarding intended use. Are there other case law developments that you think that the FDA not just should, but likely would actually be willing to adopt and incorporate into its rules?
Well, I think the debate that's raging within the agency is over the big question, which is to what extent will FDA at a programmatic level incorporate the core First Amendment limitations as reflected in cases like Corona and Amarin at the programmatic level. And that's to me the reason that the WLF case to this day is still the single best example of how litigation can have a favorable effect on FDA at the program level, because there you had a judge telling FDA directly what it could and couldn't do across the board. You didn't have a product-specific or a company-specific resolution. I mean, Amarin gets this wonderful advisory comment process that lets them get comments from FDA twice a year, and that's fantastic. But there's no reason that shouldn't be made available to all regulated entities. Similarly, Amarin gets the benefit of Judge Engelmeyer's incredibly well-reasoned and thorough opinion, concluding that truthful, non-misleading speech about off-label use is constitutionally protected, and that's the law in the Second Circuit. But I would love to have seen an order entered against FDA saying, as the order in WLF did, that FDA cannot, with respect to any product or company, purport to dictate the content of CLE, for example. So that's the litigation that I'm waiting with bated breath to see, and I'm sure it's coming down the pike.
Well, I'd like to give the agency a little bit of kudos for in the Amarin case, recognizing that summaries of reprints that essentially faithfully reproduced the results of the reprint itself, the study itself, were not a problem. And the agency said that I believe as if that had always been the case, but in fact nowhere in the guidances that were, say, the safe harbor guidances, had the agency actually said that. And that does go to a concept that hopefully the agency will pick up, which is that it is the content of the speech and not the form of it or who's saying it that really should govern. And so if you are faithfully reproducing a study, the fact that they're your slides as opposed to peer-reviewed reprint should not make a difference. And that gets us some way down the road. Now it's time for the agency to recognize that, acknowledge it, and then go further, hopefully.
Okay, with that, please join me in thanking our panelists for this informative talk today.